Hello and welcome to the webinar, Outside Local Counsel Coordination in Multinational Merger Control Projects, In-House Counsel Experiences and Expectations. Change is the only constant. I'm sure many of you attending this webinar today will agree that this old adage has never felt more true than over the last year and a half. In fact, the pace of change has been unprecedented. Now, almost halfway through 2021, it is safe to predict that the global outlook is still evolving. For companies and the legal teams that guide them, this will bring growth opportunities, but also more challenges and uncertainty. Our session today will provide GCs and investors with practical insight into the latest antitrust merger investigation trends, including enforcement activity and durations. This session will cover a range of topics, including M&A strategies, the importance of antitrust compliance given heightened global enforcement, competition law's role in supporting sustainability goals. My name is Haveen and I'm one of the editors here at the Legal 500. Before I introduce our expert panel of speakers today, I would like to introduce our moderator. Gönenç Gürkaynak is founding partner of ELIG Gürkaynak, a leading law firm based in the beautiful city of Istanbul. He leads the competition law and regulatory department of his firm. Gürkaynak has unparalleled experience in Turkish competition law, counseling issues with more than 20 years legal experience. He's received his LLM degree from Harvard Law School and is qualified to practice in New York, Brussels, England, and of course, Turkey. In addition, Gürkaynak holds teaching positions at undergraduate and graduate levels at 2 universities and has published more than 150 articles in English and Turkish. These are just some of his accolades, and I'll stop there because if I go on, it could be quite a long list, but welcome, Gürkaynak.
Thank you. So this is Gönenç Gürkaynak speaking, and I thank you for this very nice introduction. Without further ado, I'd like to present the 3 very distinguished speakers of today's conversation. We have decided to keep it chatty, so hopefully everyone is going to chime in about different topics. You have Stacy Frazier, who is the Executive Counsel, Competition Law and Policy of General Electric.
Hi, everybody.
Hi, Stacy. Thank you very, very much for being with us. Stacy is particularly fit for this particular discussion because she also has the same type of a background that Sandy and Ben also have, which is that she has seen both sides of the table. She has been a private practitioner, and she has also been a long-time in-house counsel as well. Stacy was a counsel at a global law firm after about 9 years of service there, and she's been with GE for about 5 years now, and she's an alumni of Harvard Law School. Then you have Sandy, Sanford Pastroff. He is a senior counsel, global antitrust and strategic litigation for Whirlpool Corporation. He has been with the company for about 14 years. He's also the vice chair of corporate counseling committee of the antitrust section of the American Bar Association, a Northwestern alumni. He was a partner at a global law firm with 18 years of service at that law firm. So clearly an extremely experienced and very senior person that can speak for both parts of both sides of the table. Then you have Ben Graham, the European legal director of Anheuser-Busch InBev, ABI. He has spent 6 years with a global law firm and 8 years with ABI, a King's College alumni. He has worked on a particularly challenging international merger control matter that has made quite a bit of headlines everywhere back in the day when it was done, and it was quite a difficult task to handle. That's when we met. We met with Sandy on the job as well. We've done very many merger control clearance work with him. Also with Stacy for General Electric. I was very privileged to work with her as well. So I've had the privilege of working with all three of these individuals. Again, thank you very, very much for being here. To make sure that we're using everybody's time efficiently, if you allow me, I will give the very first topic of conversation on the merger control perspectives from an in-house counsel's expectations standpoint. So what does an in-house counsel expect from an outside counsel, or how does coordinating outside counsel present challenges? And the very first question would be the importance of risk assessment, of course. So basically making sure that the notifiability analysis is a realistic one. When you're notifying in a jurisdiction, you understand what you're going to be looking at, and what else in the initial steps of a merger control filing globally. What would one particularly look into, and what kind of outside counsel reaction would be important? Stacy, if you were to do the kickoff, then I'm sure Sandy and Ben might want to chime in as well.
Sure. Thanks so much. When I think about risk assessment from the local counsel views, I think one of the things that is most critical is to do it efficiently with the other law firms involved. Often by the time we are working with local counsel, we've already done a preliminary risk assessment with a firm that we work with closely. And so I think one thing that we want to make sure is that we take the work we do with those central coordinating counsel and really take advantage of that when we go to the different local jurisdictions. That being said, I think it's important to highlight in the risk assessment local nuances that may complicate your merger review. Because so often when you're in the early stages of the merger, you're looking at it from the perspective of the US and the EU and maybe a couple other jurisdictions, but you can get hung up anywhere. And that's where I think a good local counsel will say, here's what's different about, let's say, Turkey, and here's why you need to factor that into your timing. And it's just, there's a certain customer who might complain. The markets may be defined differently here, etc. So that's one thing that I think is absolutely critical in risk assessment from local counsel, and one thing we look for right away. Also, when it comes to risk assessment, I think it's important that local counsel help you understand the risk in a practical way. So very often you're trying to decide, am I going to file in a jurisdiction? And you may have a policy of filing everywhere you trigger. Some companies may have a policy of technically possibly triggering a filing, but choose not to file there if there's no local nexus, or choose not to file there if there isn't an active merger regime. And I think a good local counsel also helps you take the risk of either complying or not complying with certain merger regulations into account, rather than sort of necessarily 100% technically adhering to some rules, but help you understand the conditions on the ground and what you want to take into account as you decide how to comply with the local regulations. So those are two things I think are very, very helpful.
Thank you. This is very helpful. Sandy, what would you add? Would you like to add anything?
Sure. I mean, I think the practical device is important. There oftentimes is a difference between what the law is and maybe how the local enforcers interpret the law. And so I think companies need to know both, right? They need to know, maybe the local enforcers would say they expect a filing, but maybe the law doesn't require it, or maybe, but I think that's important to know. But also it's important just for us to get candid advice too. I've been involved in deals where, fortunately for our companies, for Ben and Stacey and I, we have folks like us. We're in-house lawyers. Sometimes, not every company has someone who's an experienced competition lawyer. And, the outside lawyers sometimes can be so deferential that you're not getting the candid advice. And that can really be problematic. And I've seen that, fortunately, not from my side, but I've seen that from other sides. So, while ultimately, oftentimes I'm the one who has to make the decision, I want the external lawyer to be one who's going to tell me what they really think and what I need to know to make an informed decision. And that, sometimes people are so deferential or so eager to please that I'm not getting the advice that I need. At the same time, I don't want someone to be so conservative that we're doing things that aren't legally required or that might slow down a transaction. So I think candor is important, especially, if you have an in-house lawyer who's experienced. I understand, and as Stacy and Ben and I will all understand, no one can guarantee what's going to happen in the future, right? But we have to make decisions, right? And we have to, and the business needs to make decisions. And so we need advice to help us make decisions, not, well, on the one hand, maybe a filing's not required. On the other hand, you could argue a filing is required. Do whatever you want to do. That's not helpful to me, because ultimately our company needs to decide. People are looking to the in-house lawyer for our specific recommendation. And so we need lawyers to help us do that, to, say, and Gönenç, that's something that I've enjoyed working with you, that you do that, but not all lawyers who I've worked with are quite so direct. And so I think that's something that I encourage people to do is just to be clear and candid so that we can make decisions, because sometimes, you're dealing with, an uncertain situation, right? But a decision has to be made. And so that's where the candid advice to me is really helpful.
Yeah, I agree that giving textbook advice that only repeats what is written in the law is rarely helpful, and advice has to stem from experience. Then it is allowing the in-house to take certain decisions. And also an interesting point about putting yourself on the line a little bit, because one frequent example about the Turkish jurisdiction, for example, you're all very experienced, so you know the answer to the question already. But could the Turkish Competition Authority send 5, 8, 7 repeated RFIs at the last day of their review time and cut the time period and restart it forever? The textbook answer to it is, if they wanted to, it would be lawful and they could do it, and there's nothing barring them from doing it. But if you only give that answer, then it's just going to be inoperable, because it's not true. And there is a particular handling of the authority, and there are things that one has to add in that kind of an analysis. The same for carve-outs, hold separate arrangements, the same for strategic decisions as to whether you front load a particular filing or whether it's going to get too confusing. Just give us everything you have and then we'll deal with it is not a very helpful approach either. Ben, what are your points on the importance of risk assessment and the preliminary approaches to the matter?
Yeah, sure. Apologies, I survived a toddler attack there. She also attacked during our preparation, so she knows when I'm working on this. There's just two things that I was thinking about. One is almost taking a step back, is the choosing counsel. Very often, sometimes we know a jurisdiction well, like in Turkey, we know who we would talk to, but it may be that it's a jurisdiction where we don't know the counsel. And so how that process goes is very often that it gets recommended by the local counsel is recommended by another law firm, or sometimes it's a directory like Legal 500. But I think very often it's a recommendation, and then we need to kind of learn how and whether we can trust that local counsel very quickly. And it's someone that we don't really know. And so maybe it's obvious, but it's rare, is if a local counsel knows something about our business. In our case, that's relatively easy. You can go to 3 supermarkets and 3 corner stores and see what kind of beers are on the shelves and where they're put and which ones are cheap and which ones are expensive. And it's not that hard to do, but if you do it and you can talk about my competitors in a market and where my brand sits and theirs sits, then that sort of thing is impressive to us. Like Stacy will know it, Sandy will know it. We know what all of our products are. They know what all their GE products are. They know and this is the life that we walk in all day, every day. But to most people, that's maybe not so obvious. But that's the first thing. If we don't know you as a law firm, you're in a jurisdiction and we've never had contact before, then that can just kind of get us up to speed quickly, especially if you kind of have started to go into getting an interest in the company as well as the competition landscape in our industry or in the relevant industry. The other one is a bit what Sandy was saying, that no surprises, and there can be surprises of things like I mean, one that is now not so surprising is public interest commitments, but I think it was quite surprising at some point. And there's probably other surprises that I don't know about that people do know about in their jurisdiction, like I don't know, it could be formalities in order to file, it could be information that's going to be needed that's unusual, as Stacy said, but it could also be
public holidays hitting the review period, or it could come in very many forms.
Yeah, exactly. There's things that you don't know to ask about. You just know no surprises. Yeah. So I think any unusual considerations, those are always great to know upfront for in addition to the classic risk assessment things.
Yeah. Thank you. So a second topic that is quite interesting, and by the way, I'm very proud to report that it seems we have 155 participants at the moment, which is not a small feat considering the webinar fatigue that is happening these days. There are so many webinars. So thank you, all participants. We hope that this is going to be an interesting event for all of you. The second topic is how important is it really for the local counsel to see the bigger picture? And I'm not, asking it with a, service to you. Of course, I think it is important, kind of a connotation. Some general counsel, in-house counsel might say that you can keep them in silos and, they would be minding their business in their own country. And that's the extent of it. They don't need to discuss with other local counsels of other countries. They don't need to discuss with the opposing local counsel in the same country. They don't need to know the overall timings of the transaction, what we really intend to for as long as they try their best to get it as quickly as possible. The bigger picture doesn't concern them. Or it could be said that it is very important for them to work well with other local counsel, and it's important that they understand the broader context of the global transaction. What would you think of this line of thinking, Stacy?
I think it's critical that local counsel understands the bigger picture, while also understanding that the bigger picture often means that it is hard for an in-house counsel to always focus on a particular small jurisdiction. So one, you do need to understand the broader context of the deal in terms of timing. You also need to understand the arguments being made in other jurisdictions. And this is where I think it's critical that if you have, for example, 20 notifying jurisdictions and you have a single law firm maybe acting as a clearinghouse to coordinate everything, that the local counsel has a good relationship with them, because that's how, often it would be difficult for me to effectively direct the 20 different local counsel. It is easier for the local counsel to work with a clearinghouse firm and use the information they've put together. But you need to see the big picture. This is sort of live right now for me, where we have a deal and we had a discussion with some local counsels who considered a market definition that was contrary to some of the other jurisdictions we were filing. And sometimes that may be justified. And so you have to make sure everything that local counsels are working all in the same direction, because the regulators are going to be working in the same direction and they're going to be talking to each other. And so you can't have different jurisdictions making different arguments, because the regulators see through that very quickly. And so you're creating a problem. That being said, I think it's also important in terms of the bigger picture that that items are escalated outside of the central clearinghouse when it's really truly a live issue. I mean, part of the reason that often we bring in a central firm as a clearinghouse to work with local counsel. It's just that's the most efficient way to do it. But I do want to hear, and we hope that the local counsels work well with that clearinghouse firm and expect that. But if there is a live issue in your jurisdiction that you need the in-house counsel's attention for, I think it's critical you bring that forward. It's something that I want to be talking to my local counsel about that. It shouldn't be just a rubber stamp on what somebody's prepared for the European Commission and then it goes on in. So I think understanding the bigger picture to make sure everything is consistent and clear and part of the overall timing is critical. I also think sometimes understanding the bigger picture in terms of what the overall goal of the transaction is critical. It may be that in a particular jurisdiction, we're really willing to do remedies. In some jurisdictions, we don't want to do remedies. In other jurisdictions, we'd be happy to divest, several product lines if it what gets us over the line. So I think that's the other thing to understand is in a particular jurisdiction, it may not simply be about, okay, let's discuss this with the authorities, make our point and get clearance, but maybe in that jurisdiction, it's just get it through as quickly as possible, even if it ends up requiring remedies. So I think, again, what's the overall goal of the transaction is also a critical piece to keep in mind.
Thank you. Very helpful. Sandy?
Yeah, no, I agree with all of that. I mean, it does cost more, but part of our job is to make sure you're doing it efficiently. So, have a briefing note, so to speak, that provides the context you share with all of the local lawyers. So everyone has that, but ultimately the last thing you want is people taking different positions in different jurisdictions. Maybe there's precedent in a particular jurisdiction, so the easy thing to do is follow that, but you're defining markets in a way that's different than the rest of the world. So that can be problematic. And also, I think it's important for people just to understand the broader what's going on, what the benefits, why is the deal happening? I had a situation once where we were waiting for clearance in a Eastern European country, and I decided to go, in person for a meeting with the authority there, and they were asking questions that really had nothing to do with a lot of the questions had nothing to do with the local jurisdiction, but they were about the broader transaction as a whole to kind of get comfort with the transaction. And, fortunately, our local counsel, was aware of the big picture. I ended up answering the questions myself, but I was doing it too. But it just reinforced for me why it's important, because if we had a local lawyer who just knew their little piece, they wouldn't really be able to respond and wouldn't really be able to be, presenting the most persuasive reasons why the transaction as a whole was beneficial. So I do think that's really important, that people see the big picture, and that there is close coordination around the world, and also just, to go back to the initial question, that the local counsel have kind of the same approach as well. If we want people who are going to be proactive, and we'll probably get to that in later questions, but that's a big emphasis of mine. And so understanding kind of the broader goals and status and timing considerations and so forth, I think also helps people understand when and why to be proactive.
Thank you, Sandy. Ben, what say you?
Yeah, I was just reflecting on as you mentioned, the SAB Miller deal, the InBev SAB Miller deal, and I think there are priorities between different jurisdictions. While it is great for everyone to be informed, and it's important that people know what's going on, in the end, obviously there's priorities. And in that deal we had 4 countries that were preconditional, so for South Africa, China, or jurisdictions, South Africa, China, US, and the EU. And they were critical for the deal to progress. And then there was a longer tail of still only a handful of mentioned jurisdictions for clearance, and the others weren't sort of mentioned before the deal. This public takeover had to close. So it was important to understand that there are priority jurisdictions, and it was also probably important to understand locally that, like it or not, the way the London takeover code works, your jurisdiction wasn't considered so important, and maybe that means massaging an ego or understanding how that's going to fit in the fact that we're going to have to close a deal. So we're going to have to find out a way. So you know from day one that you're not going to be wagging the dog in, I don't know, I take Moldova as a random place, as a country that is not one of the key places. You need to understand the bigger picture and understand also that where you stand in that bigger picture. I think is also important. The other thing that we did, I was just thinking about how we communicated with people. I mean, a briefing note at the beginning and notes throughout about what's going on is quite useful. I think something that we tried and struggled with a bit was kind of having calls when you would have all the local councils on it. That seemed to be a bit of a less effective way of communicating with people. You ended up with sort of too many people and too many voices, and that didn't work so well. So in my experience, changing information worked. You couldn't really shortcut it by having a big town hall. That didn't really quite work.
Yeah,
you have to be a little bit more conscious than that.
Real-time communication is quite time-consuming in these kinds of multi-J filings. It's true. I'd like to ask all three of you a question, not really directly going into the heart of expectations from outside counsel or the coordination bit, but while I have this type of an experience all around, and while you could comment on the substance of things and trends, I'd be curious as to whether you're observing anything that you find particularly concerning in the merger control world, the trends of it. You could be feeling that the increased emphasis on public interest might be becoming an issue, or you might be feeling that there's not enough coordination between the authorities. So some authorities are waiting for the other authorities just for the heck of it, while in their jurisdiction there's actually no substantive issue or anything of the sort. Basically, I don't mean to suggest answers, but with all of your experience, is there anything that you find concerning in these multi-jurisdictional filings, or too much? Maybe again, let's start with Stacy.
Sure. I think, and I'm a US-based lawyer, so a lot of my view is often informed by what's happening in the US. But at the same time, I think globally there's just a lot of change and uncertainty, and that makes it very difficult to advise on a particular jurisdiction. So yes, for bringing in the public interest standard and not knowing exactly the metrics that your merger is going to be judged against can be very difficult. And some of the rule changes coming out of Europe, while not necessarily concerning if you're not a digital company, as a non-digital company, you wonder how some of them are going to be applied to you and what does that mean for you. So I think there's increased focus on concentration and increased scrutiny of all mergers. And for a company like mine, which makes aircraft engines and gas turbines and health equipment, we aren't quite sure what some of that is going to mean for us, other than increased uncertainty. And that just makes it hard to plan and to make recommendations to your board and your senior leadership. And so I think what we want is sort of greater harmonization and certainty in what the rules are going to be and how they're going to be applied to my particular company.
Yeah.
Yeah, I agree with that. I mean, I think public interest is in many countries, it certainly is a consideration, although it's not expressly mentioned. Yes, in say South Africa, that is clearly part of the law, but I think as a practical matter in many other places, it's a consideration too. What's the impact on local employment, even if the stated competition law principles don't recognize that. And it does, in theory, if you're doing a global transaction, right, there is some impact of what happens in what's positive for one country, and it may not be as positive for another country. But I do think more transparency would be helpful from that perspective. To come back to the point about local counsel, it's also important for people to be candid. Some people don't necessarily, the answer would be, well, that's not a factor under the law, but we're hiring people to tell us what's going to happen, in the real world, and what should we expect? Should we expect that, someone who wants to object is going to go and find, the right person in the right jurisdiction to go and, even in the EU, if I'm going to go to in a particular country, the senior officials in one country, to get them to lobby the European Commission to act in a certain way, we can do whatever the rules are, they are, and we can deal with them, but having more clarity on the rules is certainly helpful. It's, predictability and preventing surprises is a key part of our job. So I do think that would be certainly very helpful for us. So Ben?
Yeah, I was just thinking that in Europe, I think we've seen in the last month or so a little, I forget who the interview is with, but a little more a previous high-ranking official in any case, of skepticism around the whole sort of merger control process and whether it had allowed mergers to happen that shouldn't have happened. I guess it has also happened in that debate is to some degree happening in the US as well, at least in the tech space. So if you're asking what is concerning about developments in merger control, it's what does that mean? Does that mean merger control will get stricter, or does that even mean more authorities will start to wonder that previous clearances that they've given that they shouldn't have given, and that they will start to backtrack on them? I mean, that maybe it's very exceptional what's going on in the US, but or what goes on around big tech in the US. But I think at least you've seen that there, and you've seen this some skepticism being brought in as a sort of at least in a mediatic way, maybe not officially by the authorities, but at least in the media, you've seen it come in. And so, yeah, if something is concerning, it is okay. Stricter enforcement is one thing, but then even questioning previous decisions and the certainty of previous ones, that is even quite another thing to start bringing in. I mean, it might be right from a policy point of view, but from as a company faced with it, it's obviously something you can't really prepare for. So
as a quick aside, just on this issue of retrospective reviews, there's been certainly debate in the US on whether there should be more of that. But to the extent that there's more concern about that, I do think that's one thing that companies need to be thinking about is post-closing documents, right? And advice from our local counsel on that. There's been some deals, I can remember one, a hospital merger in the US where the deal closes and then people start creating documents saying, hey, without this merger, we wouldn't be able to jack up our prices by X, Y, or Z. Yeah. And, sometimes, they actually did it because of the transaction, but sometimes, business people create inaccurate documents. But, to what degree is, a retrospective review of a transaction an issue? And what does that mean for both in-house and external lawyers in terms of how carefully we need to be keeping up the training about the documents you're creating, because someone looking at the deal later is going to say, aha, you've acknowledged this merger was anti-competitive.
Yeah, no, it's very interesting. We have two questions that are nicely annexed to what we're discussing, and one is coming from Carly, who has been at both sides of the table again in reverse order. So he was with GE, now a private practitioner with a private law firm again. And Carly, well, actually before that, he was with another international law firm, now that I remember. So he's asking something that Anne Riley is also underlining, which is that it seems in these transactions, outside counsel more and more needs to check not only for merger control matters, but also for foreign investment rules in general, and Carly adds also for national security matters. So are we seeing it imminent that probably law firms will have to develop an expertise on the side, and only delivering merger control results won't be enough, and they will have to do a sweep of the regulatory landscape in its entirety to provide all of the regulatory map out, if you will, of the proposed transaction for that jurisdiction? Or can they make do with saying, I just do antitrust law when you ask national security questions or foreign direct investment regulations. That's not my cup of tea.
Well, go ahead, Stacy.
Oh, no, I was just going to say it's an interesting question because I feel like every time I've been counseling on deals recently, someone asks me, well, what about FDI or national security? And we all sort of look around at each other trying to figure out who's responsible for that. I think that, yes, we need our outside counsel to develop expertise in that. But I think the reality is most of our outside counsel already have expertise in that. It just may not be rooted in the antitrust lawyers. And here, what I would ask of local counsel is just to coordinate very closely with the client. For example, we have an attorney who's not me, who's an expert at, fortunately, at FDI, at GE, and he has preferred law firms and a preferred way to do it. And so we just want to make sure that, doing the antitrust analysis doesn't automatically encompass the other pieces if the client hasn't asked. That's the one piece we'd expect. What we often have is a law firm flag it for us, say, have you checked FDI? Do you want us to? How do you want to handle that? Because what we don't want to have is, the antitrust firm and the M&A firm, and then maybe a third FDI firm all working on the same work stream, because it is an emerging area that we're trying to figure out how to check. But the head raise of, hey, have you guys thought about that? Because very often you may not have, or we have thought no further than, boy, someone should check for this, is appreciated. And I think, I think about, Carly, you know what it's like to be in-house. I think about what it was like, and you don't really get to be a siloed practitioner. And so I think there is a little bit the same that of our antitrust lawyers, we would expect them to be able to sort of raise the issue, if maybe not answer the question, but raise the question for us.
Yeah, the business, they expect the legal function to answer the legal question. So saying, well, I'm just the antitrust lawyer is not an acceptable approach for us, right? So we need to work either with our in-house colleagues or external counsel to answer that question. So as Stacy says, working together is really important, but saying, that's not my job, that's not an acceptable answer, I think, for any of us. Our job is, if that's not our expertise, is to find out who has it and get the answer to the business client. So to them, it's more seamless. But sure, I think we need to be thinking about things like FDI. Now the European Commission's focused, from what I'm reading, also on, state aid is another consideration, right? So, we need to. It's a big world too, and so this is where we need our outside lawyers to help us make sure that we're keeping the most important things on the radar. And if they don't have, at least flag it, and if they don't have the expertise, maybe help us get it, and then work together to come up with an efficient way to answer the question.
Yeah, if I go back to something that everyone repeats a lot, right? The no surprises principle. If I take that, if I got my advice from, it was relevant to us, South Africa, and they just told me the antitrust was going to be fine, but they didn't mention, you're also going to have R1 billion to spend in public interest commitments. That wouldn't be great advice, right? that would, and I wouldn't know anything about South Africa unless you tell me. And the same applies. We know EU and US better, and it's more obvious. So we may think about these things more readily, but obviously, to take it back to local counsel, if in Turkey there's the foreign direct investment that is triggered, the only person who's going to tell me is you, Gönenç. Like no one else is going to tell me.
I think that's part of the change. It's a very interesting question by Carly and Anne, in the sense that this was always sort of a positive duty assumed on the outside counsel, but ask me around 2015 and I would say, yeah, we have the expertise, but if the client asks for it, then we offer the national security angle to it and the FDI, because we would assume that the transaction counsel might be taking care of it, or we wouldn't want to come across as aggressively marketing something, we know this, would you like to get advice on that as well? Now, when we get a question, if the relevant market warrants an analysis of national security issues, or if there is a particularly applicable FDI matter, it just is assumed as a positive duty that we flag it. We don't give an all-out legal memorandum that is going to create significant legal fees for the client, but we will at least flag that someone needs to ask these questions and someone needs to respond to it. It may not be us, but did you make sure that someone is asking these questions? It wasn't like that. So I think that the trend has changed because there is so much emphasis now on the FDI matters, and a lot of jurisdictions are handling these things differently. Luckily, the Turkish jurisdiction is quite light on the FDI side of things, but if you're going into a regulated market or in a defensive industry where national security is going to be an issue, obviously, then you need to provide advice.
And one thing I'd add on that, we're talking about how FDI and antitrust and these other areas aren't siloed from a practitioner's perspective. I think it's also important local counsel help us understand how the different agencies can work together, because there are jurisdictions where maybe the antitrust timeline is really aggressive. And so you might be able to see a foreign investment process drawn out if the antitrust process has to sort of be wrapped up on a shorter time frame. So when there's an interplay between the two, when maybe antitrust can shift into foreign investment, that's something that I also think is really helpful for local counsel to flag for us.
Yeah. All right. On to communication with the competition authorities. This is actually a tricky one, which also warrants a bit of a conversation with such very experienced in-house counsel as to how they choose their local counsel in different jurisdictions, because this will go into them having to allow the local counsel to go and have face-to-face conversations with the public authority, and not only the FCPA concerns, so Foreign Corrupt Practices Act concerns, and making sure that the outside counsel is going to act in an ethical manner and there will be no violation of company policies or violation of law to get a particular result. So choosing the outside counsel, making sure that the outside counsel's interactions with the authority are efficient but still on an arm's length basis, that it is an adequate follow-up but no one is smothering the authority either. How do you strike the balance? What do you do normally? Maybe let's follow the reverse order. Ben, would you like to take this?
Yeah, sure. When it comes to competition authorities, obviously it's very important to have a local counsel that knows the authority, that knows the people, that knows the structure, and that can explain. Well, it can explain the relevance of it if it's relevant. There's plenty of transactions where I don't need to know that you're best friends with the head of the competition authority because it's a simple transaction. So you don't need to sell me on those credentials. But when it's relevant, then sure, I want to know that you know how it all works, but also that you're judicious in thinking about how and when and who should actually meet with the authority. We've had plenty of instances when we don't really need to go, when we as the company can actually trust the outside counsel to do a lot of that interaction. I think actually in Turkey, that's the case. Gönenç, for example, very often I think you do a lot of the interactions yourself.
I do.
And there's not that often that even we need to be part of the interaction of the legal counsel, let alone have executives come along. So, but in other jurisdictions, it will be the way to unlock the door will be to have an executive who comes and can explain the transaction, and it will reassure the regulator that they have the right person in front of them. And I think a local counsel knowing that about their authority and knowing how best to approach it, and having the confidence to back up those convictions and how they express that to companies is important. I don't want you telling me it's critical that executives come when it's not, and I say it the other way around is true as well. So it's not just a matter of saying bring people. It's always good to meet the authority. That's fine, but what is it? Understanding in your jurisdiction how your authority works, and then whether it's really relevant that the companies invest the time and energy in visiting, I think is something we always want to know.
Yeah. And the outside counsel obviously might be selling something that is really not germane to the analysis. Moving on that example of, I'm best friends with the head of the authority. It's say for the Turkish competition authority, for example, it is quite technical, and the case handlers will do their jobs, and you need to be there for them to ask their questions, and you need to make sure that efficient responses are flowing in, that timing matters are handled accordingly. But if an outside counsel were to come forward in Turkey and say, "Ooh, I know the president," it's so irrelevant to the merger control analysis, and it's either going to backfire because the case handlers will feel disrespected and bypassed, or it's going to be ineffective. But because there were bureaucratic pleasantries, the smiles and "would you like another cup of teas," the client may be misled to think that this is how it is going to be handled. So yeah, I agree that again, it comes back to Sandy's point, basically, the outside counsel being candid and real in providing advice. Sandy, anything to add on these?
Sure. To me, the key is credibility.
Yeah.
With your counsel and the regulator. It's when you think about it, you talked at the beginning about RFIs. The last thing you want is getting unnecessary RFIs and delays because the regulator is not confident in the credibility either of the outside counsel or the company, right?
Mm-hmm.
I mean, that's the worst thing that can happen. And so you definitely don't want a situation where everything's got to be in writing, it's got to be an RFI, it's got to be a written response, and so credibility is crucial. And to me, I want my outside counsel to kind of advise me on what's the best way to maximize credibility. So is it bringing in an executive, or is it providing more information than they've even requested, or providing someone for an interview early on, or whatever it is. But how can we get the regulator comfortable with the truthfulness of the information that we're providing, that we're not withholding information, because that is typically going to make things run more smoothly. And so I think that's really critical. The other thing is, it's not always about this deal, it's about the deals that may be coming down the line. And so, do I want to be taking an ultra or have a local lawyer who's taking an ultra aggressive position on what to my company is a minor deal, and now I've angered the regulator, and when the next important one comes along, I've got a huge problem. So there's never any benefit to the company to lose credibility. And so I think it's looking at the big picture, not only of this transaction, but of whatever might come down the line in future transactions. And so it's important to me to understand what in a particular deal is necessary to maintain that credibility. I agree with Ben. I don't want to be sending in executives every time just to do it, because people are uncomfortable. You've got to make sure that they're properly trained and prepared and all of that other stuff. So it can be time and expense. But when it's important, then I also want to know that too, and I want to plan ahead for that, right? And so I think it's each transaction thinking about what can I do. I think the other thing in terms of credibility is having a candid discussion of the timing of how much of when you start engaging in a deep way. Some people think, hey, well, let's have radio silence and maybe we'll get close to the end of phase one and they won't pay attention and they'll clear it. But I always find that kind of a risky thing, because what happens if the case team realizes I don't have enough time to get answers and run up my recommendation all the way up through the hierarchy? So the easiest thing for me to do is go to phase two because I've run out of time.
Yeah.
And that's on us,
Yeah.
right? As the lawyers, the antitrust lawyers running the deal, to make sure that doesn't happen, because that's an own goal, right? Where it's avoidable, but that doesn't mean you do it in every case. But I want the local lawyer in each jurisdiction to kind of help us think through what the right approach is. Yeah.
Yeah. And the credibility of the local counsel obviously also helps, I hope, in making sure that the in-house counsel is able to defer to the local counsel's judgment from time to time, especially about these, points like timing of the follow-up and all that. It very frequently happens in Turkey that right after the filing is submitted, the next day, the client may send us an email message saying, will you be following up today or tomorrow? And then you have to explain to the client that a premature follow-up is going to backfire. It's just going to mean that basically either you're going to get questions just for the heck of it because people are not ready and they're giving you something to chew on, or you're going to waste your first follow-up. So you will do a follow-up rather late in the calendar because you were forced to do an early follow-up. I find that more and more experienced in-house counsels always, but even the ones that are newly coming into the multi-jurisdictional filings matter, they're more and more deferring to the local counsel's touch on these kinds of matters, which is, I believe, a good thing. Stacy, did you have anything to add on this particular point?
I agree with everything that's been said, especially the point Sandy was making about, if you're a repeat player in front of these agencies, it's really important that every deal is taken seriously, both by the company. And that's something that we have to do sometimes too, is push back on some of our principles and say, I know you feel your global deal is being held up by a small jurisdiction unnecessarily, but if we play this poorly, your next global deal is going to be even more held up. So you need to sit tight and let the lawyers do their work. But yeah, so I think that's also where, when we're being pushed to do aggressive things by the principals, it's also helpful for the local counsel to help us remember the importance of that long-term relationship. And, yes, could you make that argument? Yes. Could you try that? But you need to put in the but of yes, but think about next time. And I think very often you do hear lots about connections with the local authority, and candidly, what matters is not connections, but experience with the local authorities. We're looking for technical expertise and integrity, and our reputation and commitment to a reputation of integrity, it matters in every country in which we file. And so that is going to be how we select outside counsel at every level. So, at the end of the day, it really comes to, what is your success rate been in front of the agency, and is it for the right reason?
Yeah. A question on international cooperation. Nick Peristarakis is asking, do you generally agree to grant waivers for interagency cooperation in different countries, or are you generally more reluctant? And would your answer change depending on the agencies involved or the antitrust issues involved? It's a question on substance, and we meant to get into international cooperation, so this is a nice segue to it. Stacy, if you would like to.
We typically grant waivers. I don't, for the most part, all you're going to do is slow yourself down, potentially frustrate an agency. There may be a unique situation in which we decide not to grant waivers, but since I've been in my job, we've always granted them. It doesn't help your reputation of cooperation with the agency if you don't grant them.
If any of you had an instance of rejecting it, would you share it? Not obviously, not the specifics, but how did you do it? I've never come across one. I've been doing this for 23 years. It's always granted. And I always feel, how do you reject it anyway without raising a suspicion? And, what would be your valid reason, or would you just brazenly, categorically say, no, I'm not giving a waiver? Sandy, what are your thoughts on this?
I've never said no. It goes back to my earlier point about credibility. I mean, look, even if you have concerns about a particular jurisdiction, if there's a political concern or something, I mean, at the end of the day, you're gonna, one way or the other, the information can be provided. I mean, regulator A, who you don't want to give a waiver, can figure out what RFIs to send you to get the information that they need. So as a practical matter, I think it makes sense to do that, so it's hard to say no. As I said, you know, when you start losing credibility, it just creates more cost and more delay.
Yeah, I just think, I mean, I don't have an instance of us saying no, but I think it was interesting to see in again the SAB merger of which authorities talk to each other, and I guess that varies depending on the transaction. But in that case, I mean, historically, you would expect, at least I would expect that people would ask the US and ask the EU, like, want to have those connections. I think what we found was more what seemed to be, like, I don't know what was going on behind the scenes, but it seemed to be more of a sort of southern connection, that South Africa and Latin America were more similar in what they were asking about and what directions they were going in their analysis, and the US was going another direction, the EU was going another direction. So it's sort of interesting to see what happens when you let the cooperation happen. Probably more than whether you let the cooperation happen, because I don't know, as you say, Gönenç, I don't know how you say, no, I don't really trust your country, or whatever it is.
Yeah.
That's quite a difficult conversation to have, I suppose.
Yeah. I mean, exchanging evidence, I can understand on a, you know, data protection matters may come into gameplay. One country might be an EU member state and the other wouldn't be, you know, there could be scenarios, but when it comes to basic conversations between case handlers of different authorities, to say no is really overly aggressive. And yeah, you would probably lose your credibility, as you all say. So James Musgrove from Canada, he's asking, picking up on the issue of future credibility, how do you manage positions taken with respect to issues which may affect future deals, such as market definition, which is quite sensitive, really, and goes back to the point Sandy made, that, you know, one language should be spoken consistently all throughout. Otherwise, it's just going to mean that you lack your credibility, or who are characterized as principal competitors of the company. You know, you give a list, and then apparently you haven't been entirely transparent and all that. You are losing a degree of future flexibility. So how do you strike the balance is the question. Sandy, wanna?
Sure. I mean, I think that's part of that. I think that's an important part of my job, and I'm sure Ben and Stacy would agree, is thinking about the bigger picture. You know, hopefully we have a sense of what could be happening going forward, and again, we're thinking about this deal, but we're thinking about future deals. So yeah, I mean, from a tactical standpoint, you can always do things like, you know, competitors include but are not limited to A, B, and C, right? So as a lawyer, you obviously the simplest thing is you never say these are the only competitors and that kind of thing when you can avoid it, right? But I think it's also, as I said, important just to be thinking about kind of the broader perspectives. And it is difficult because in some jurisdictions you might have different precedents on how markets are defined, right? And so, you know, sometimes the local lawyer in company X would say, well, let's just say this because in this particular country the numbers look better. But I think we need to be thinking about it more broadly. And so, as much as possible, kind of understanding the direction of the company, you know, what deals are coming down, you know, in the future, and be about, you know, thinking about this transaction, but more broadly. And the challenge sometimes is on small deals because you want to do them quickly. You want to get it done. It doesn't raise issues, right? But you need to be thinking about the bigger picture. So sometimes you see the frustration there, like why you're so focused on things where there's not going to be a problem with this deal. Why do we need to hire Gönenç on this deal in Turkey? You know, because there's not going to be a problem. Just do it yourself. But no, let's just, every deal has to be given careful thought when you're a multinational company, and you know, the deal that you're doing may not be the last one.
Mm. Eli is asking an interesting question, which asks us to switch our perspective a little bit. Whenever we talk about merger control matters, inevitably, we already assume that we're sitting on the steering wheel of the filing of the matter. Eli Katz from New York, he's saying, how do you handle these issues when you're representing the target? You may not have direct contact, you may not have control, you may not have a power of attorney in the game, depending on the jurisdiction. It may not be a joint filing. So your reputation and credibility is still on the line, but you're basically indirect in your handlings. Have you found yourself in this situation? And are you generally trying to penetrate to the decision making and the quick reporting in these instances, or do you feel, well, the SPA is making it a matter of the acquirers, so if they mess it up, it's their problem?
Sorry, I'm going to have to dive in and give my apologies for needing to. I'm just being called away for something, so I really apologize. I'm sorry, I'm not going to answer the question. I don't have experience of it in any case. Of being the target is a very interesting
That
question.
is perfectly fine, and we're wrapping up in about 5 minutes anyway. Thank you, Ben. This was great. It was great to have you.
Thank you very much.
Thanks,
everyone.
I could answer this one.
Yes,
I mean,
please,
I think,
and then Stacy. Yeah.
I think try and find a way to give yourself as much of a voice as possible. It may be the case, if you're the target, you probably know more about the business. You may know more about the business than the acquirer. Yep. So you can volunteer to do things, offer to help, to have a greater role. It may cost you more money, right? Because if your lawyers have more of a role than they otherwise would, it costs money. I've had that where the business people say, well, hey, we're selling the business, so why do we even need lawyers, right? Let someone else. Like, well, no, we need to think about this. But I think, if you are able to be helpful, you have more of a likelihood of being involved in the discussions, and then the positions that are taken and how things are articulated would be more likely to take into account your perspectives. And then, of course, in the actual agreement, right, you can also protect yourself too in terms of, rights to participate in meetings with regulators and so forth.
Yeah.
And I'd also add that even if the SPA gives control of strategy to the buyer, you as a seller usually have some sort of best efforts obligation or some sort of obligations. And if you truly believe something that the buyer is going down the wrong path, I do think you have an obligation under your SPA to raise that. I mean, ultimately, it may not be resolved in your favor, but if you have legitimate concerns and you don't raise them, and that could be a problem as well. So you also have to think about, what are my obligations to participate in this process and have an active role, even if I don't drive strategy.
Yeah. So one last question that is bringing us to the end of the list that we had in our preparations as well. Obviously, we've taken a detour with some very valuable other questions, but this one is actually featured in what we had discussed during our prep talks, and that is the matter of carve-outs, hold separate arrangements. The question is coming from Daisy Walzel in Germany. And the question is, would the podium be willing to share its experience, if any, with carve-outs for the purpose of expediting the closing regarding other parts of the transaction? Are they credible as an option at all? Allow me to say that as far as the Turkish jurisdiction is concerned, carve-outs are categorically rejected. And we have litigated this through and through as well. The holding of the High State Court, which is the highest court in the administrative line in Turkey, is that they ask two questions. Was this notifiable? Did you close before the approval of the Turkish Competition Authority? If this was notifiable, and if you closed before the approval of the Turkish Competition Authority, then I will not charge the Turkish Competition Authority with the additional positive duty of proving that effects have actually taken place on Turkish soil. So there is a presumption of the effects being there because it was a notifiable transaction. There have been some instances where there were certain workarounds that weren't carve-outs, but rather splitting the transaction into two with two SPAs and congregating what doesn't have that much of an effect on Turkey under one SPA, and making sure that all the competitive concerns of the authority are captured with the other SPA that is not closed. But overall, I must say that some jurisdictions are rather categoric about it. And my observation of the trends, I don't know if you would agree, Stacy and Sanford, is that the trends are more and more authorities are distancing themselves from the idea of carve-outs. It looked like a good innovation back in the day, but now it doesn't seem to be used that much.
I agree. I think even in jurisdictions where there have been carve-outs, if you went to the regulator in that jurisdiction, they would say, no, it's not permissible, and we're opposed to it. So I think it's a very difficult thing to do.
Yep.
I mean, I suppose if you, the one thing I would say, if you were doing it, I would be more transparent about it, and you could do a carve out and hold separate and all that other stuff. Much better to do it that way than look like you're doing something illegal, or so at least at the very least you ensure there's no collusion, right? But that still doesn't address the gun jumping issue, right?
Yeah.
And I just think more and more, when jurisdictions like Turkey are so adamantly against it, it's hard to see many other jurisdictions would say, well, that's perfectly fine with us.
No.
I mean, especially because if you think about it, the places that you would want to carve out are places that have a system that's very slow, and maybe you think you could carve it out because it doesn't really have an impact on the broader transaction, but those jurisdictions already know that, right? So if you've created a system that triggers lots of transactions that might even have a very tangential connection to your country, and you've knowingly done that, are you necessarily going to be amenable to saying it's fine to carve out our country because it's almost inconsistent with the whole need to have a carve out in the first place?
Yeah. Stacy?
I completely agree. I mean, it is a question you get a lot, I get a lot. I don't know if you do, Sandy, but very frequently, the minute you say, well, this jurisdiction looks like it's slower, can you close around, is very quickly a question you get. So we often need local counsel to arm us with facts and just help us be aware of gun jumping issues in the local jurisdictions. It is certainly something we are seeing spreading. And because that's the kind of pressure we often get in-house, we really need to be able to show, here is why you absolutely positively cannot push this issue.
Yeah. Thank you. This was truly a pleasure and a privilege. Thank you, Sandy, Stacy, and in his absence, also Ben. It is one thing to hit about 160 people at some point of the webinar, but it's quite another thing to keep all of them engaged and end 10 minutes after the intended time with still 120 people. That's all you're doing, and thank you for keeping it full of content. I hope to be able to moderate another event of Legal 500 in the future, and definitely we'll be looking forward to more of nice, interesting, sophisticated competition law thought. Thank you, Stacy and Sandy.
Thanks, Gönenç. I appreciate the opportunity to speak and the good discussion.
Thank you.
Thanks, everybody.
Take care, everyone.
The Legal 500 would just like to say a thank you for moderating today, and the panelists who came. The discussions were really insightful, and I'm sure some of the viewers would like to maybe even rewatch some bits because we know you covered some really pivotal points. The discussion will be going up on our on-demand service in a couple of days. So definitely hop onto the website and you'll be able to view it there. So thank you, everyone, and enjoy the rest of your afternoon.